Chapter 9, Titles, Deeds, and Ownership Restrictions. In Chapter 9, you'll be presented with the methods of legal instruments used to transfer title of real property, discussing voluntary and involuntary alienation, title insurance, the two types of notice to title, the essential elements of a valid instrument of conveyance, covenants found in deeds, governmental and private restrictions on ownership, and the various types of leases. In the end, you'll be able to differentiate between voluntary and involuntary alienation, explain the various methods of acquiring title to real property, and describe the conditions necessary to acquire property by adverse possession. You'll be able to distinguish between actual notice and constructive notice, distinguish between abstract of title and chain of title, and explain the different types of title insurance. You'll be able to describe the parts of a deed and the requirements of a valid deed. List and describe the four types of statutory deeds and the legal requirements for deeds, and list and describe the various types of governmental and private restrictions on ownership of real property, and distinguish among the various types of leases and liens. Well, here's your vocabulary for Chapter 9. It's quite extensive. A person holds vested ownership rights in property because of title. Title is a legal concept signifying ownership to the collection of rights called an estate. Equitable title is a beneficial interest that implies a person will receive legal title at a future date. Also, the interest that a buyer receives upon executing a contract prior to the title closing. So once an offer is accepted and you have a executory contract, meaning it's not closed yet, during that period that you're doing all the inspections, appraisals, getting loans, all that time, that is when the buyer has equitable title in the property. Acquiring legal title is through alienation, and alienation may be voluntary or involuntary. Alienation is the act of transferring ownership, title, or interest in real property. Voluntary alienation is with the owner's consent and control. Involuntary alienation is without the owner's consent and control. Voluntary alienation is accomplished through deed or will. A deed is a written instrument used to convey an interest in real property. It conveys legal title. Wills. Testate means that the deceased person prepared a will before death. So if someone dies testate, means they had a will. If they die intestate, they means they didn't prepare a will. Now, testator and testatrix is your male and female words for the person who leaves a will. And real property is transferred to the devicee. Notice that has two E's. Involuntary alienation is accomplished through descent, escheat, adverse possession, or eminent domain. Descent is when a person dies without leaving a will. Remember, I told you that was intestate, and the property descends to the heirs. Escheat provides for the government to take the property of an owner who dies intestate and has no heirs. Think of that as the last time the state has a chance to cheat you. Adverse possession is when a true owner sleeps on the owner's rights. It's kind of like abandonment and squatter's rights, and we'll talk about that in a slide coming up. Eminent domain gives the government the power to take the property for a public purpose through a legal process called condemnation. Okay, here's the conditions for adverse possession. You can remember it by the acronym HOTCAN. Hostile possession, open possession. The taxes have to be paid by the adverse possessor for a total of 7 consecutive years. then they would have a claim to the title. It has to be notorious and flagrant public possession. So the squatters have to basically just move in the house, have the utilities turned on in their name, get the mail delivered, and be able to do that 7 years paying the taxes without being disturbed. If the owner comes along, say 4 years into it, and says, "What the heck you doing in my house? Get out," then adverse possession ends at that moment. Then the owner's going to have to do whatever it takes necessary to get them out, which would be an eviction. There's two types of notice to legal title. There's actual and constructive. Actual notice is the direct knowledge acquired in the course of a transaction. It's witnessed. Constructive notice is legal notice. That's recording documents in the public records. An acknowledgment is a formal declaration before a notary public by the grantor that the signing is a free act. So when it comes to a deed, the deed has to be notarized, and it's an acknowledgment. And what the acknowledgment says is that the grantor, the one giving up the property, deeding the property over, is doing it as free will. Nobody's forcing them to do it. So if you get a big old scenario question asking you whether, give you a big old long scenario and they ask you, is this actual notice, constructive notice, this notice, or that notice? The way that you will be able to tell that it is constructive notice is if it says it's recorded in the public records. If it doesn't say anything about being recorded in the public records, then it's actual notice. Title history. Chain of title is a complete successive history. It goes all the way back to the original land grant back in the 1700s. Nowadays, title companies only have to do an abstract of title. That goes 30 years back. It's a condensed report of the title search found in the public records. It's given to an attorney who studies the abstract and decides whether the title is marketable or not. And the attorney's title opinion is usually not guaranteed. That's why we have title insurance is a contract that protects the policyholder from losses from defects in the title. Florida does not require title insurance, so don't get confused with that. It's the lender that makes it a condition of the loan. Licensees are not qualified to give an opinion of title. They must advise parties to contact an attorney or a title company. And licensees first must obtain a current opinion from an attorney before quoting an opinion that title is good. Title insurance, you have owner's policies and lender's policies. The owner's policy is issued for the purchase price. It protects the new owner and owner's heirs. It's not transferable from one owner to another owner. If they sell the house, the new owner has to buy their own policy. And it's a one-time premium paid at closing. The lender's policy is issued for the unpaid mortgage amount. It protects the lender against title defects, and it's transferable. It protects the lender up to the outstanding loan balance, and most lenders require it as a condition of making the loan. Again, a one-time premium paid at closing. Deeds. That's a written instrument that conveys title, and there's two parties to a deed. There's the grantor and the grantee. The grantor is the owner giving title. The grantee is the new owner receiving title, the buyer. Parts of a deed. You have the names of the grantee and the grantor. Now's the time you're going to have to learn your ors and your es. Ors give, es receive. Consideration, what's being given in exchange for title. The words of conveyance, that's the granting clause. The interest or estate being conveyed, that's the addendum clause. I kind of like to think of that as the habitat clause. How long are they going to live there? Fee simple or life estate. It helps me remember the Latin term. Any exceptions or reservations? Deed restrictions, appurtenances, the legal description. Now take note of these last two bullets. They're very important because there's questions that float around out there that's kind of distracting and may lead you to answer the question wrong. The first one is for a deed to be effectively conveyed, legally conveyed. All that has to happen is the grantor delivers it to the grantee and the grantee accepts it. Legal title passes at that point. It does not have to be recorded. Questions floating around out there ask you, when does legal title pass? And one answer might be when it's voluntarily delivered and accepted. And the next one might say voluntarily delivered, accepted, and recorded. It is not the one with recorded. It does not have to be recorded. Now, signatures. A deed has a signature of the competent grantor, which is the seller, and two witnesses. The buyer does not sign the deed. So again, question could come up, give you a big old long scenario, and ask you who signs the deed. They'll say the grantor and two witnesses, maybe one answer. Grantor, two witnesses, and the grantee may be your other answer. It is not the grantee. The buyer does not sign the deed. A valid deed needs to be in writing. It will have the names of the grantor and grantee. The grantor, the seller, has to be of legal capacity. The consideration has to be described. What are you giving me for me giving you? It will have the premises clause. That's everything in the beginning, the date, the granting clause, all that kind of stuff. Okay. The addendum clause, remember I called that the habitat clause, is the one that says whether it's going to be a fee simple estate or a life estate. The season clause is a clause that states that the owner owns the property and has a right to sell it. They can convey the deed. Okay, the way I remember that is it's talking about owners being able to change and selling the property. Seasons change, owners change. That's how I remember what that one is. Then you've got the legal description. It's signed by a competent grantor and two witnesses, not the grantee. It's voluntarily delivered and accepted, but it's not required to be recorded. Don't forget that. Types of statutory deeds, you got 4 of them. There's general warranty deed, special warranty deed, bargain and sell deed, and quitclaim deed. General warranty is the best deed. It's the one that's required in the sales contract, does not state what type in Florida. Everybody's going to get a general warranty deed unless the contract states something different. It contains all the covenants and warranties available. It includes the following covenants: the season, that the promise that the grantor owns the property and has a right to convey it, that it's free of liens and encumbrances, that the grantor will deliver any legal instrument if required. That's the further assurance. Quiet enjoyment is peaceful possession undisturbed by claims of title. Warranty forever, that's the grantor's warranty to defend the grantee's title should anything come up. And again, this is the one that's required if the sales contract does not state the type. Special warranty deed states that the grantor did nothing to encumber or cloud the title, and that the grantor's not going to warrant the title against any acts except by the grantor or the grantor's representative. So I like to think of the special warranty deed as a deed that has kind of a special promise, and that's the person who's selling the property, the grantor. They're saying, I didn't do anything, nor did my representatives, to screw up the title. Okay, that's the special promise they're making you. That's all. Now you go on and you go to bargain and sell deed. Okay, it's got the granting, addendum clause, and season clause. There's no future warranty, and all it does is convey the title that the grantor has. It does not protect the grantee from clouds or claims on the title. I like to call the bargain and sale deed the yard sale deed, because at least with the special warranty deed, you're getting that special promise that the person selling it to you or their representatives didn't do anything to screw up the title. Now, they don't know about anybody else, but they didn't do anything. On a bargain and sell deed, what you see is what you get. They ain't making a promise of any kind. Quitclaim deed, the most misunderstood deed. That is where the grantor quitclaims to the grantee all the grantor's rights, titles, and interest. It does not transfer property. Okay? It does not have a season clause. What is a season clause? A season clause is a clause in a deed that the owner says, I own it and I have a right to transfer it. Quitclaim deeds are not transferring property, therefore they do not have a season clause. It provides the lease protection for the grantee. There's no covenants or warranties. It's sometimes used to clear clouds on the title, and it can be called remiss, release, and quitclaim. Special purpose deeds, a personal representative's deed, is appointed by a will or by a court to sell the estate of a deceased person. Guardian's deed, guardian acts on behalf of a minor. Committee's deed is used when the owner is legally incompetent. Tax deed is used when the property is sold for back taxes. Ownership limitations and restrictions. The two general categories of restrictions are government restrictions and private restrictions. Both have several subcategories of restrictions and limitations. Government restrictions you can remember by the acronym PET. Police power, eminent domain, and taxation. Police power implemented by zoning ordinances, building codes, and health ordinances. Eminent domain by just compensation in a condemnation proceeding. And then taxation is our property taxes. Private restrictions are remembered by the acronym DEL. Deed restrictions, easements, leases, and liens. Deed restrictions and restricted covenants. Deed restrictions are part of a deed. They affect only one particular property. Restricted covenants, often recorded with the plat map, affect all the properties in a subdivision. So to give you an example of what they're talking about there, let's say we all live in the same subdivision. We can't park on the street. We can't park a boat in our driveway. We have to get permission to paint our house so they can approve the color, things like that. We all have to abide by those rules. Now, let's say that 3 of the homeowners live on waterfront lots. They have a deed restriction that restricts them to only build single-story homes. Okay. Now, all of us other folks in the subdivision, we can build 2-story, 3-story if we want. But they can't because they have that deed restriction. Because they're on the waterfront, they're only allowed to build single-story homes. Easements. That's the right to use a portion of an owner's land for a specific purpose. It does not convey ownership. And you have types of easements. There's 4. Easement appurtenant, easement in gross, easement by prescription, and easement by necessity. Now, easement appurtenant and easement by necessity is basically the same thing. The easement by necessity is court ordered. The easement appurtenant, the owners have agreed on it. They didn't have to take it to court. They just made an agreement. So, easement appurtenant involves the adjacent parcel of land. It's like a landlocked thing. Easement in gross benefits an individual or business entity, such as a utility easement on your property, which allows the utility companies to come fix their wires. They don't have to get permission to come in your backyard or whatever. Okay, that's a easement in gross. An easement by prescription is where someone has used for 20 years or more continuously open and uninterrupted use of maybe a pathway. Okay? They go to court and they get it declared an easement by prescription. And then, like we said, easement by necessity is for landlocked. Again, that's a court-ordered one. Encroachments is unauthorized use of another's property. A fence or garage located beyond the boundary. Now, it becomes an implied easement after 7 years. You'll see that 7 years keeps popping up. It's kind of like, I think that's the time limit to consider something abandoned. Lease agreements grants the right in possession and use to the lessee, the tenant. It does not transfer ownership. It must be written and signed to be enforceable if it's over a year. It also requires signatures of 2 witnesses if over a year. Licensees may only use fill-in-the-blank lease forms approved by the Florida Supreme Court. We cannot type up lease agreements for our customers. That is considered practicing law, and we cannot do that. There are 5 types of leases we're talking about with commercial property, okay, or non-residential. You have gross lease, net lease, percentage lease, variable lease, and ground lease. A gross lease is just one fixed amount that covers everything. A net lease is where the tenant pays a fixed amount of rent plus building expenses. A percentage lease is where the tenant pays rent based on gross sales received. A variable lease, the tenant pays a specified rent increased at set dates. And a ground lease is a lease on land. It's usually 99 years. Your first math problem. Calculating rent owed for a percentage lease. A lease calls for a monthly minimum rent of $1,200 plus 4.5% of the annual gross sales over $550,000. What is the annual rent for the year if the annual gross sales were $979,500? The answer would be you take the monthly rent, $1,200 times 12, because there's 12 months in a year. That's going to give you your base rent. Going to pay that no matter what, whether you make a penny or not, $14,400. Then you're going to have to pay that 4.5% premium over any income or sales that you make over $550,000. Well, you made $979,500, so you got to subtract. What's the difference? $429,500. You multiply that number by 4.5% because you have to pay the premium on that income, those sales, which make it $19,327.50. So when you add those two up, that is the annual rent for the year, $33,727.50. Another math problem, calculating rent owed for a variable lease. A shopping center rents for $22 per square foot with an index of 2.7. They're talking about the consumer price index. Now, next year the index increases to 3.2 and they want to know what is the adjusted rental rate. Just looking at it, you think, oh my. It is not hard at all. Wait till you see how to solve this. It's so simple. Take the $22 per square foot and divide it by the 2.7. That's what the $22 is based on initially. Then what happens is it goes up the next year to 3.2. So you take $22, divide it by 2.7 and get that big old long number there. Don't mess with it. Just leave it in your calculator the way that it is. Hit your multiplication button, 3.2, and voila. Next year you'll be paying $26.07 per square foot. Assignment and sublease. A lot of people use these terms interchangeably and they're not the same. An assignment is when the tenant assigns all of the lease property for the remainder of the lease and they have nothing more to do with the property. A sublease, there's 2 ways to sublease a property. Either the tenant assigns a portion of the lease property, like renting a bedroom and they're still living there, or the tenant assigns all the property for less than the remaining term. So for instance, maybe the tenant's going to go out of the country for 2 months and they sublet the property for the 2 months. Once the original tenant gets back, the subletter, if you will leave and the original tenant comes back. So again, assignment, the original tenant has nothing more to do with the property For a sublease, the original tenant, stays involved. Liens. That's the right to have a debt satisfied by some property owned by the debtor. The lien holder, the lienor, may have the property sold to pay the debt of the owner, the lienee. Liens are recorded in the public records, so therefore, because they're recorded in the public records, they're constructive notice. There are general liens and specific liens. General liens are judgment liens, IRS, and federal state tax liens. Specific liens are property tax liens, special assessment liens, mortgages, vendor's lien, construction liens, and mechanics liens. So general liens, they can go after real and personal property. Specific liens are going against the specific property. Yeah, like your property taxes. Voluntary and involuntary liens. Voluntary liens, examples are mortgage and vendor's lien. Involuntary is judgment liens, tax liens, and construction liens. Now, lien priority. You have superior liens and junior liens. When a property is sold and the proceeds are there, think of a bucket with all the money, the proceeds, what the sale was, okay? First thing that's going to happen is they're going to pay all the property taxes, no matter how old they are. All the property taxes get paid out of that bucket of money. And then if there's any special assessments on that property, that's going to get paid too. And then if this was an inheritance like a probate, they're going to pay the federal estate tax. All right. Now we got a bucket with some of the money left. Okay. Now what they're going to do is they're going to pay out according to who recorded the lien first, with the exception of a construction lien. A construction lien gets to go back to the original date that services were performed or goods was delivered to the property. Okay? Now, subordination agreement. What's a subordination agreement? A subordination agreement is someone who agrees to take a lower priority for whatever reason. Maybe they should be number 2, but they're going to be number 3 and let number 3 go and be number 2. So they'll get paid before they should have.